All right, we're going to get started. Welcome, everyone. I'm Alison Korn. I'm the Assistant Dean for Experiential Education here at UCLA School of Law, and I'm excited to welcome you to our final session in our Teaching Justice webinar series for the 2020-21 school year. Today, the topic is Teaching Justice through Abolition, and we are very excited to present Alexis Hoag from Columbia Law School.
I'm Layla Halas. I'm the Director of Experiential Learning over at Tulane Law School. I'm also thrilled to welcome you. I am a member alongside Allison in the Best Practices Committee. And this whole Teaching Justice webinar series is part of the CLEA's Best Practices Committee. It's a project. As Allison mentioned, this is the finale, the grand finale of the semester, but we are excited to be kind of reissuing this series next fall, so please stay tuned. This series has featured a number of innovative faculty, all thinking about new approaches to teaching justice, reflecting on wisdom from the current social movements and its intersection with immigrant rights, racial justice, economic rights, child welfare, and more. We have really had a knockout series, so I look forward to continuing the conversation in the coming year. And we have everything recorded, so if you go to the CLEA's Teaching Justice website and you missed one, you can catch it there, and this session will be posted there as well.
So yeah, just as Layla said, the session is recorded and it's going to be made available on that CLEA teaching website alongside all of the others, and we'll circulate all of that information to the listservs and otherwise once the session concludes. Alexis is going to be posing a couple of questions through a poll feature that Layla will launch shortly. And in addition, please use the chat function early and often to pose burning questions or reactions as the presentation is taking place. One thing that Alexis has asked is if you feel comfortable, go ahead and put in chat what you teach, the subject matter, what type of clinic or what type of course you teach, so we can get an idea of who's here and what folks are teaching. I think that that's it. We encourage everyone to leave their video up as they feel comfortable, but please do remember to mute your audio function. And with that, Alexis, we will turn it over to you. And thanks again to everyone for joining us for today and for the entire series.
Great, Allison, Layla, thank you so much for that wonderful introduction. It's really a pleasure to be with you today. And as we talk about teaching justice through abolition, please know that this is us struggling, figuring out, identifying best practices together. And even though we have this 1 hour together, please know that I am available as a resource to you. I hope that's true of all of us. We are all in community together as we navigate these issues. And I'm quite new to teaching. I met Layla, I think it was last summer at the CLEA workshop. I had just started at Columbia Law School as somewhat of a fellow. So I'm a practitioner in residence at the Eric Holder Initiative of Civil and Political Rights. And then what allows me to teach at the law school are these additional administrative titles. So I think I'm known as like an associate research scholar and a lecturer in the law. And then next summer, I will be transitioning full-time to Brooklyn Law School to join their faculty to teach doctrinal courses. So criminal law, criminal procedure, evidence. But at Columbia, what I've been doing is offering these courses that we call practicums. Columbia is careful about their nomenclature. There's something different that's a clinic. That's different than an externship, it's different than a practicum. But what I do are offer courses that have a seminar component, and then outward facing field work, often in partnership with an existing organization. So that's the model I'm using. At other institutions, that is known as a clinic, but at Columbia, we use the term practicum. And much of my teaching is also informed by my own practice. So I was a capital post-conviction defense attorney with the federal defenders, and then later transitioned to the Legal Defense Fund of the NAACP, working on racial justice issues in the criminal context, and then sort of in other civil contexts. And then of course, my teaching is really informed by my own experience as a student. I was at NYU. I know there's a number of NYU law folks on the call. It's a pleasure to see you. But I was a student of Randy Hertz, his juvenile defense clinic, a student of Tony Thompson and Kim Taylor Thompson in their criminal defense and advocacy clinic, which later incorporated reentry. And then of Marty Guggenheim and Brian Stevenson. So I lean on all of them in this presentation as well. I know this is a webinar. It will exist on the web for folks to check in and learn from later, but I hope that during the course of the time that we have together, you'll use this as a conversation, and feel free to drop in on the chat box. Feel free to interject, unmute yourself if you're comfortable. Once I do start sharing my slides, I won't be able to see the chat box, so I'll be relying heavily on Layla and Allison to chime in and let me know as questions come in. But it's really my hope that I'm not just talking at you the whole time, but that you'll interject and you'll share some of the tools that you have been doing in your classrooms and with your students. So I see right now that the vast majority of folks are offering currently a clinic or some sort of experiential opportunity. We have almost 90%. I'm hoping that some of the tools and the themes that I discussed can be applied to a podium class as well. So keep that in mind. And then have you talked to your students about abolition? It's about half. So, and I think that's great. I'm excited. Our students are ready for it. And I think in many ways, what we've already seen in the classroom is that our students are slightly ahead of us in some ways. And then in terms of what sorts of topics are being covered in class, we've got a community economic development clinic, externship, international human rights, bail pretrial issues, professional responsibility, crim defense clinic, law, food and policy, constitutional rights clinic. So a whole range of areas. I'm hoping that what we share today, what I introduced to you, is something that you can incorporate in your teaching. And then please, if you're already doing this, share what you're doing for the benefit of all of us on the call, and then folks that'll tune in the future for the webinar. So with that, I'm going to see, I messed this up sharing my screen probably every class. So let's see how it goes here. Okay, let's see, play from start. Do we see the blue, teal, teaching just wonderful? I appreciate the thumbs up. So I can only see about 5 or 6 folks, their images. And so if you do have a question, if you do want to interject, please unmute yourself, or I'll be relying on Layla and Allison to help me out there. Let's see. So brief overview of how we're going to spend the next 45, 50 minutes. I want to start from the same starting point. Abolition is a term that has been around for centuries. And so I want to clarify what I mean when I say abolition. I'll tell a little bit about how I came to abolition. I think for all of us that are incorporating, thinking about abolition, it's a journey, our coming to it. So I want to share my own story if I can. I want to tell you how it is that I incorporate abolition in my teaching through the model, through the system I have in place at Columbia's Law School, and then give you some kernels, ideas, suggestions for how you can incorporate abolition in your teaching. And then I have a lot of resources to share, book titles, law review articles, organizations. This is much of this work, as we'll talk about, is happening outside of law schools. And I think it's really important for us to be aware and have knowledge and be in conversation with what's going outside of the law school. And I know for so many of us that do clinics, that's what we do all the time anyway, but I think it's worth mentioning. And then I don't just want to relegate, the last few minutes to Q&A. Really, this can come all throughout, but we will have designated time at the end for questions. So here we go. And then also the slides that I have, I'm hoping that I can, if they're not hosted, on CLEA's website where the webinar video is, that you can contact me directly for them, or I can make them available to Allison and Layla to share, because I have a lot of hyperlinks and materials listed in here. So what do I mean when I say abolition? I lean heavily on, I'm an ongoing student of Ruth Wilson Gilmore and others. This was this fabulous photo of her that was on the New York Times Magazine. Some of you may remember from the summer of 2019. But she really clarifies that abolition is about presence. It's not absence. It's about building life-affirming institutions. And so much my background is in the criminal legal system. And so I think primarily of abolition within the context of carceral abolition, abolition of the carceral state, which includes police, which includes prosecution, and then relying heavily on incarceration, on jails, on prisons, on detention, immigration detention centers to deal with our social issues in this country. And so if we're only thinking about the buzzword, the buzz term defund police, it doesn't really flesh out the full meaning, which is not just to take something away, but to focus on the replacement. So presence, not just the absence. And I do want to raise some counter arguments that came up, I think, from sort of this established Democratic Party, that sort of this, what's now become almost like an old guard liberal approach to reform, and this idea of like reform versus abolition. So in December, many of you may have remembered this, but President Obama, I think he was giving an interview like on Snapchat. And this was really, you know, coming in the heels of all of the uprisings, not just in this country, but of course, all around the world that we were all witnessing. This interview was on Snapchat because of course we're still in the pandemic. There wasn't a live interview, but he really dismissed and trivialized the term defund police. He referred to it as quite a snappy slogan. And he really leaned into this idea that we should be able to reform the criminal justice system so that it's not biased and treats everybody fairly. And I think folks that are really active in abolition don't have a lot of faith anymore on these sort of Band-Aid fixes that legitimize the system, that prop it up, that respond through sort of implicit bias training for police departments when you've got people that are being killed by police officers. And so there's some real tension here, and I want to discuss this, and I hope this is something that you'll grapple with and introduce to your students. And then, you know, Obama said it, he suggests that in a democracy, we need to play a game of addition and not subtraction, which I thought was really curious because that goes right back to what we heard from Ruth Wilson Gilmore. He later then did clarify his statements. I think it was either on Trevor Noah or Jon Stewart. But I do want to raise this sort of counterpoint within sort of the liberal context of abolition, because it's definitely there. Let's see. And then here we have Amna, who I know gave a talk earlier this series with Jocelyn Simonson. And these are statements she has put in the Law and Policy, Economic, Law and Political Economy blog, which I've hyperlinked, and I definitely suggest you all use it as a teaching resource. Amna, Jocelyn, others have engaged in material that really walks us through how to teach and incorporate abolition, both in the doctrinal sort of context of classes, podium teaching, and then also in more of a clinical experiential setting. But abolitionists work toward eliminating prisons and police and building, imagining, creating an alternative and varied set of political, economic, and social arrangements, institutions that can then respond to many of the social ills, which is what we have been relying on prisons and police to do. And I really want to make clear that there is room for the state in abolition. I think it's easy without really deep engagement to think that what we're asking for is to get rid of all sort of police, get rid of all institutions. No, it's to really reimagine, reorient, transform them. So there is room for the state in this. And importantly, abolitionists see their struggle as part of this unfinished work of transforming the afterlife of slavery. I think a lot about Reconstruction and that hopefulness and the promise that we had in about that 10-year period that really was snuffed out because of racial terrorism and violence and the jurisprudence that wasn't willing to be as aspirational as lawmakers when they were passing those Reconstruction amendments, the Civil Rights Acts of the 1860s. So this is really unfinished work. And again, it's looking at the economic, political, and social ordering of this country in a better way, a more expansive way of doing it in a way that isn't life annihilating, but rather, as Ruth Wilson Gilmore tells us, is life affirming. So I guess before I get into my guiding principles, I do want to sort of interject how it is that I came to abolition. I did mention that I started my career as a death penalty defense attorney. And, I'll actually stop my screen share because I know it can be somewhat, there we go. Are we back without the screen share? Okay, perfect. Change my view to gallery so I can see everyone. Great. So how did I come to abolition? I started as a assistant federal public defender in Nashville. I was representing individual clients. They were had already been convicted by the state of Tennessee and sentenced to death, had navigated state post-conviction. Here we were at federal habeas. Those of you that do any amount of post-conviction work, our federal work, or teach Fed courts know how limited the avenues for relief can be when you get to federal habeas. It was frustrating. I often had to think about redefining victory. It wasn't necessarily always getting a ruling from the court that granted habeas relief. That wasn't always a reality for my clients. We waited a lot. I also explored for the first time something I never knew about in law school, pathways to restorative justice, defense-initiated victim outreach, where we hired people to work as sort of a go-between and reached out to victims' surviving family members to talk about, if they had questions, if they wanted to be in conversation with our client, if they supported execution, if they supported the death penalty. So this was really mind expansive for me in practice. But it was also frustrating because I noticed, as many of us that do traditional criminal defense work in clinics and in our own practices, how limited it can be to confront the same issues again and again. And you don't necessarily have the tools or the ability or the time or the resources to really work on transformational system-wide change. And so that was part of the reason why I left the federal defenders and then went to the legal defense funds. The legal defense fund, through mostly, but not all, an impact litigation model, where we are trying to bring about systemic change through an individual case. LDF has really expanded its advocacy to do policy work, to do organizing. We have lots of non-lawyers on staff, community organizers that go in and mobilize local communities where we have had litigation, where we're contemplating litigation, and then areas where we're not even thinking about litigation. We're really working on changing the sentiments and the organizing and the information in a local community, and really empowering, shifting power away from certain actors and empowering community members. So that, again, for me, was very mind expanding. And then I was sort of plucked from practice by Bernard Harcourt. Many of you know Professor Harcourt. He's a colleague of mine at Columbia Law School, and invited me to come to Columbia to teach full-time as a practitioner in residence. And the first class we co-taught together in the fall of 2019 was Abolition, a social justice practicum. And I really had to get up to speed. And I tell my students every semester, I taught the class again, the fall of 2020, I am as much a student of abolition as I am a teacher. And I invite you to identify in that same space, because we are all learning this process. But for me, abolition was something that was so expansive, and it allowed me really to reimagine, reorient, rethink, be creative, be dynamic, and potential sort of pathways for a solution that wasn't always about filing a case and waiting for a legal decision. Because I think all of us in practice that do clinics know that's not the only way to bring about change. And so I am very much a student, an ongoing student. You'll see the resources that I share with you at the end, podcasts and books are very much all on my shelf. This is one that I just bought, which I'll share with us again later. We Do This Till We Free Us by Miriam Kaba. Highly, highly recommend, a collection of essays. But I am a student of this as well. So I'll go ahead and reshare the screen. Let's see. Okay, and we're back. We see the PowerPoint. Wonderful. So these are my guiding principles of abolition. I really want to make that clear. These are guideposts that I use. They're not the only guideposts, but it helps orient me to abolition. And again, I want to make sure we're all on the same page so that you know what I mean when I say abolition. So abolition does invite us to imagine a future without carceral punishment, without prisons, without jails, without immigration detention centers. It encourages us to think both critically about the conditions that cause harm, and then dynamically about how we can address and prevent harm. And so it encourages us to not just think about calling the police when harm occurs, but what else could make a community safe? What else could address that harm? And then after harm occurs, not necessarily relying solely on prosecution in the criminal legal system to bring about a conviction and then incarceration to address harm. What else could help bring about some sort of solution, a repair to harm? And then it acknowledges this link between the institution of slavery and then the carceral institutions that we operate today. And I think that's really helpful framing, and it's something that there's been so much more scholarship about in the last 20 years. I lean hard on Michelle Alexander's The New Jim Crow, Ava DuVernay's 13th. And that sort of framing is really hopeful to me. It reminds us that this is a long arc of justice. This isn't something we're just engaging in anew, and it helps explain how it is that we have the impact of the policies that we have. I think our students are really frustrated by how our laws appear neutral, policies appear neutral, but why is it that we have these gross racial disparities, gross economic disparities in who is being targeted, who is being confined, who is on the receiving end of prosecution and incarceration. Abolition also denounces race, gender, disability, and class-based subordination, racial capitalism, settler colonialism, moves away from institutions and policies that would perpetuate that kind of subjugation. And then importantly, abolition is both expansive and it's generative. And again, Ruth Wilson Gilmore tells us it's about presence, not absence. And I want to emphasize as well that abolition recognizes there is room for the state in delivering these services. I think at first blush, perhaps Obama, it was very easy to say, defund, it's just taking things away. And what do you do? Who do you call then when you're experiencing a robbery, if not the police? There is room, and abolition does create room for the state in this. And so I want to make that clear that it's not taking away all government support, government funded social services. And then what's really key is to know for me is that abolition is not an end point. It is an ongoing process. It's a method for transformational change. And Miriam in the book, We Do This Till We Free Us, reminds us that we may not see the change that we're demanding during our own lifetimes. But what we can do is energize and organize, introduce our students to these ideas, and realize that there is value in moving forward. And this is something I also learned from Derek Bell, who I had the privilege of working with in constitutional law way back when in law school. But he very much firmly believed in this value in challenging subordination. And then something that we adopted in the abolition practicum, which is a helpful guiding principle for me, is that abolition is both a theory and also a praxis. So it's something we can employ in practice. It's something we can also talk about theoretically. And something that I found really helpful during that first week of class, and I'm happy to share my syllabus with you, but to orient my students so we're also speaking the same language, we have the same understanding of a framework, was to introduce some of the theories of abolition in week one, and then moving on, obviously, to fieldwork and practice. Okay. Additional points to consider. You don't have to have all the answers. And I think that's true for law teaching in general. But I think it's helpful to note, and it's okay to learn alongside your students. And this actually came up, I think, in our last session with Deborah Archer, is that it's okay to grapple with these issues and to not have it all figured out when we present these ideas to our students. And I think it's a really helpful learning tool for our students to see us as someone who's seeking out and looking for answers and thinking through areas of practice, of theory, and for us to be getting comfortable with it as we teach. I mean, it's so helpful for them to know that, this is a process. I don't have to have all the answers. I don't have to have it all figured out. Because look, my professor, doesn't have it all figured out. This is also very humbling. It makes you be vulnerable in front of your students, which maybe isn't the most comfortable space for us to be in. But I want to affirm for you that it's okay, and I actually encourage it. And again, as I talked about under the guiding principles, abolition is not the endpoint. It is very much a continuing, ongoing process. And then, as we know, in much of the work that we already do, so much of the most exciting, dynamic work in abolition is happening completely outside of law schools. And I think it's a real privilege for us to be able to share some of these ideas and concepts with our students. So I want to talk about how it is that I teach abolition. This is one way. It's not the only way. It is a model for you to consider, maybe take bits and pieces of, maybe not take any of and do something completely different. And I also want you to know that the way that I taught abolition in September 2019 is different than the way I taught it in September 2020. I won't be offering this class in the fall. I'll be teaching evidence, but I would teach abolition differently in 2021. I am learning, as we all learn each semester, things that we try out, things that we introduce. We're not sure how it'll land, and we tweak it the next year. So this is definitely a course that I would dynamically tweak each subsequent year. This is language that I've taken from my syllabus. This course will explore social justice road to punitive abolition. Bernard and I co-teach this together. We both have extensive experience in death penalty post-conviction litigation. And so you will see a heavy emphasis on capital punishment. That's not the only way to talk about and to teach abolition. But I do want to present that as a caveat. So in this class, we will, in Abolition and Social Justice Practicum, focus on abolition of capital punishment, and then also the dominant punitive punishment paradigm in the United States. We will investigate in this class how to abolish the death penalty, how that might be achieved, but also what it might mean more expansively, imaginatively, to abolish abolition in the context of policing and of prisons, and then punishment more broadly. Those of you that know Professor Harcourt, he has a background in philosophy. He's a scholar of Foucault. He translates a lot of Foucault, so you'll see little bits of Foucault in our syllabus. So this class was really unique. My appointment is technically through both the college and the law school. Bernard is appointed through the college and the law school. So we actually invited upper level college students. We had 6, I think this last semester. We may have had 5 the semester before, but it was majority law students. We did have 3 LLMs. Last year, we didn't have any LLMs this year. But students were on integrated, both college and law student teams. We had 7 projects. I think one of them did not have any law students, but the rest had at least 1 or 2, college students. So one team only had law students. Every other team had a mix of college and law students. Research projects will be in the areas of capital punishment, criminal defense advocacy, and appellate litigation. You can be much more aggressive and expansive with abolition. In many ways, we were quite tentative in the fieldwork projects that we did. I think it could have been even more abolitionist, more radical, but we really stayed in a lane that we were comfortable with and that we had exposure and experience to. But I think in many ways, we limited how radical our students could be in their field work. And so that's something that I would reconsider moving forward. And I encourage you to consider the same. Again, because this is a practicum, we were partnered mostly with outside organizations. And so I want you to consider thinking about how it is that you can keep this all in-house if that's the way that you teach your clinic. Let's see if I can go back. Okay. This is again borrowed from my syllabus. The syllabus I use with Professor Harcourt. This is our course outline. It's a 13-week model. And so in week 1, we did introduce theories of abolition, and I'll talk about some of the reading material that we assigned. We spent a lot of time anchoring, as I do in all of my classes, anchoring this in anti-Black racism. Those of us that practice within criminal law know that that is very much a part of the way the criminal legal system operates, has always operated in this country. And so we did some early reading by Paul Butler and Brian Stevenson out of that fantastic collection, Policing the Black Man, that Angela Davis edited. I don't want to conflate. Angela J. Davis, not to be confused with Angela Y. Davis, who we'll also be speaking about. But Policing the Black Man has a great collection of essays, and Condemnation of Blackness by Khalil Muhammad, who used to be at the Schomburg Center, but now is at, I believe, Harvard. But that was those were anchoring weeks for us. Introduction to abolition, and then also let's talk about the criminalization of Blackness. And then we just dove right in topically. So we grappled first with reform, this sort of tension between reform, defund police, which we explored even just a little bit in our introductory comments with former President Obama. And then more radically, a step forward with abolishing the police and getting into some readings with Miriam Kaba. And then some of the legislating and conversations that have been going on nationally. We saw Minnesota grappling with abolishing police. We witnessed, I believe it was Seattle, that removed school resource officers from public schools. And so we were examining some of what was going on around the country. And then also, of course, in our seminar. These are all the seminar components. This is a 3-credit class. And we had 3 in-class hours of seminar a week. And then students were expected to work, I think it was approximately 10 hours of field work throughout the week. We talked a lot about qualified immunity in Section 1983 litigation. This was new for Abolition 2020. We did not discuss qualified immunity much. It is devoted away in the fall of 2019. And this was very much in response to what was going on nationally. There's pending legislation at the time coming from Representative Presley and Amash about ending qualified immunity, tying it to the fact that Section 1983 really originates from a Reconstruction Act, the Ku Klux Klan Act of 1871, and how qualified immunity is this judicially created factor that defense, affirmative defense for police officers, or really any state actor that violates the civil rights of somebody, and has, through jurisprudence, been interpreted to be absolute immunity. So that was something that the students and also our field work focused on this year. Abolish prisons. I think that's what most of the scholarship we see is about. Abolition within the criminal legal system, and then intimate partner violence. We were really toying with how to incorporate abolition in practice in a traditional criminal defense setting. And we relied heavily on Nicole Smith's forthcoming article. It is fantastic. It should be out, I think, any minute in the NYU Review of Law and Social Change, but how to incorporate abolition theory and practice in a traditional criminal defense clinic. And we actually partnered the field work with a public defender organization. And then we spent extensive time, as you can see, weeks 9 through 12, which you may not do on abolition of the death penalty, given, again, Bernard's and I's background. In 2019, we actually took our students to Montgomery, Alabama. It was a real highlight of the course. We took them to EJI's, the Equal Justice Initiative's monument and museum, the Legacy Museum. We took them to the Dexter Avenue Baptist Church, where Martin Luther King Jr. and others organized the Montgomery bus boycott. It was a really powerful trip for our students, and it was something we obviously weren't able to do this year, but it really highlighted and sort of brought together so much of what they had been working on. And then something that I would love to, I mean, you could teach a whole class on this really, but alternative remedies to address harm. And we brought in folks from a restorative justice organization in California, which I have more details on a subsequent slide, to talk about something other than prosecution and conviction and incarceration to deal with crime and harm. These are the anchoring sort of texts that we used in week 1. Allegra McLeod wrote an article that was really forward thinking in 2015. And it's funny to talk to her about it now because she's quite critical of it. She's like, I could have gone harder. I could have been more radical. But Prison Abolition, Grounded in Justice, she revisits the institution of slavery reconstruction, really anchors the way the criminal legal system operates today in the institution of slavery. Again, AMNA has a lot of great scholarship in this area, but we introduced our students towards a radical imagination of law. And then Dorothy Roberts has an introductory piece in a Harvard Law Review volume that was really devoted to abolition. And I have a hyperlink to that later on a slide, but that was a fantastic anchoring text for our students. And the field work that we did. We had, I didn't name all the organizations on this slide, but Qualified Immunity, our policy project, was with the Constitutional Accountability Center. And they were looking at advising state lawmakers and federal on how to go about arguing for, pushing for the end of qualified immunity. And so they were drafting sort of model legislation. Our students were really looking at different policy arguments, indemnification sort of issues. This actually cuts off opportunities to explore meritorious constitutional violations. So it truncates the ability of courts to really evaluate these claims and issues. And so that was, we had weekly check-ins with CAC, the Constitutional Accountability Center. I had a separate supervisory meeting with the students, and they produced fantastic written work and oral collaboration with the organization. Of course, this was all done on Zoom. That's why I've got that graphic on the right. We had students actually partnered with an organization that was deeply involved in qualified immunity litigation before the Fifth Circuit. They lost in district court in Texas. It was a lethal use of police force. And the students actually wrote portions of the brief. So that was with the MacArthur Justice Center. Our supervising attorney that we partnered with happened to be a Columbia Law School grad. It was a really beautiful partnership with the students. That was the one project we did not have a college student on, but the other ones we did. Intimate partner violence, looking at alternative remedies to harm. We partnered with the New York County Defender Service. It's a local public defender organization. Again, happened to have an alum at that school, which was nice, not necessary. And they had encountered a growing number of, I guess it's called sort of when the complaining witness does not testify. So it's like evidence-based prosecution. And you've got a call to the police, complaint of IPV, and then a charge related to that. So it might be assault, it might be battery, some other criminal charge. And then the complaining witness decides once trial comes around, does not want to testify. So then the prosecution relies on the police report, possibly neighbors, maybe if there was a visit to a medical healthcare facility, some of the documentation from that. And so they were really curious, well, what do we do then when you've got the person that has experienced the harm for any variety of reasons, who does not want to move forward? What then can we do? What should we be doing? And so the students were looking at different sort of alternatives to prosecution. A lot of these exist under the sort of threat or in the shadow of prosecution. And so there's not really a lot of volition involved in that, but they were looking at sort of different policy arguments, different organizations that have been working on these issues. One of the college students had worked at Survived and Punished, which is a fantastic organization that works with women that have often experienced intimate partner violence and then end up sometimes murdering or assaulting sort of, there's a criminal charge related to, they're sort of fighting back. And so having that student's experience with Survived and Punished was a real boon in this fieldwork project. There was a confidential detainee matter that I can't really speak too much about, but the students were partnered with outside attorneys doing somewhat traditional litigation like work. And then again, given my background, Bernard's background in capital punishment, we had students working on active capital cases in federal habeas, again, with a partner organization, Phillips Black, which is located in New York, that does a lot of capital post-conviction work, but out of jurisdiction. And so these were cases in Alabama and Mississippi. And then the project that we have called the Path to Abolition is one of the, probably the most imaginative and exploratory for the students. It's something that I have a fieldwork component in my capital post-conviction defense course that I teach in the spring, so I'm teaching it right now. But the Path to Abolition invites students to think about potentially in what is the next state under the state statute, the state constitution, to get rid of the death penalty, how to go about doing that. So they have to do some sort of threshold research on like what states still have the death penalty. And then once they've narrowed it down, what's going on in that state. And so they start talking to, we often introduce them to organizers, maybe even victims advocacy groups, conservatives concerned with the death penalty. It's a national organization, has chapters all over. And then trial attorneys, post-conviction attorneys. And so they get their finger on the pulse of what's going on, and maybe they can help with that, or they do their own project informed by what's going on the ground. And so that tends to be sort of the most expansive of the fieldwork projects. Last year's class came up with the digital abolitionist, which is something that's beyond just the death penalty, but it's a resource I'll share with you at the end. But really thinking about an ongoing conversation that exists virtually for people that are affected by the criminal legal system, impacted by scholars, organizers, activists, to be in conversation, to have resources sort of online virtually. And so that's to me one of the more exciting fieldwork projects. And you kind of never know what you're going to get. So you have to have that faith in being okay with giving your students that amount of freedom. These are just some photographs of our trip in 2019 to the Equal Justice Initiative. It was really a grounding experience for the students, particularly going to the monument. Those of you that have visited, that's the photo that's in the middle of the large sort of monuments that memorialize each of the individual counties where racial terrorism occurred, and the list of names and dates. It was really, really powerful for our students. And we lament that we weren't able to do that this year. So this is where we sort of transition into suggesting how it is that you may be able to incorporate abolition in your teaching. And so I've highlighted some other areas where abolition might be helpful for you to think about as a theoretical framework, but also in practice. So this idea that we want to come up with ways, generative ways, to address harm that don't rely on punishment and police, that don't rely on incarceration and incapacitation. We want to reroute services and funding. So not necessarily funding for police and prisons, but what else could make a community safe? Perhaps robust after-school programming for children, safe and secure housing, educational opportunities, living wage jobs. And so this starts to bleed into lots of other areas besides the criminal legal system. And so I've included some of them here. And I invite any of you that are already starting these conversations with your students outside of just carceral abolition, outside of a criminal legal context. I invite you all to share some of those experiences now. If you're comfortable doing so, feel free to unmute yourself. You can also drop things into the chat. And again, Allison and Layla, if anything comes in, just sort of alert me so that we can pivot. But I really want us to think about how this model for change can be applied in other areas. And there are examples out there. I know immigration is one in which we already have so much overlap with the criminal legal system that this idea of abolishing ICE, abolishing detention centers is very much in conversation, both in the practice side and in theory. I know the Columbia Journal of Race and the Law just hosted a symposium on abolition of the child welfare system. Dorothy Roberts writes extensively in this area. And so to start thinking about these kind of areas. I also want to share a lot of resources with you. And so even if your fieldwork projects in your clinics and your experiential courses aren't purely abolitionist, I want to encourage you to carve out maybe chapters or readings for your students throughout your seminars that introduce them to this way of thinking. Our students are so hungry and so ready for this information. I think about my own experience in law school and in a criminal defense clinic where we wanted to be public defenders. And we wanted to zealously represent and advocate for our clients. And holistic defense was something that was probably about 10 years into practice. I was in school from 2005 to 8. And that was new and exciting today. My students, they want to dismantle the system. So yes, they want to be public defenders, but they want to work themselves out of a job. That is their approach. So I want all of us to give them the tools to be able to carry that imaginative thinking with them into practice, and the confidence to bring up these issues in the offices in the organizations in which they work. Because these sort of seeds for imagination can be so powerful, and we don't know how beneficial it can be until we get that email, like X number of years later, that share back some of the ways that they're bringing what they learned from school into practice. So Our Prisons Obsolete, fantastic foundational text from Angela Y. Davis. Sort of the modern abolition, carceral abolition movement coalesced in the late 90s around Angela Y. Davis and other organizers through critical resistance. And this is one of the texts that came out of that. You can actually find a PDF online, and the chapters are very digestible and easy to assign. Abolition and Democracy, it's a term borrowed from W.E.B. Du Bois, also from Angela Davis. Ruth Wilson Gilmore's Golden Goulet. She is a geographer by training and talks a lot about space, environmental justice, prisons, abolition. I think it's a really valuable text. Again, feel free to just take off chunks and chapters. Alex Vitale's End of Policing, and then again, Miriam Kaba's, and this is the text that I have that I held up, and that's also on the slide, just came out, I want to say within the last month or so. There's so much legal scholarship. You'll see much of this has come out or is forthcoming in just this last couple of years. I didn't repeat Amna Akbar, Dorothy Roberts, and Allegra McLeod's pieces here because I wanted to make room for all the other stuff. I really want to highlight on the right-hand column Nicole Smith-Futrell's forthcoming piece, particularly those of you that are teaching in criminal defense clinics, because there are such powerful tools, ways to incorporate abolition in seminars, ways for students to think about challenging system-wide issues when they're in a criminal defense office. We brought in as a speaker Shantae Parker, who's head of the Neighborhood Defender Service in Detroit, that really thinks critically and dynamically about system disruption. She recognizes as the public sort of defender institution, one of the defender institutions in Wayne County, that there are limits to what her office can do, what she can officially do, but she works in collaboration with organizers that are very much on the front lines of abolition in Detroit. And so to think about how students can be in partnership with on-the-ground organizing, even if they are in a more traditional sort of office space, or if you offer a more traditional sort of clinic model. And then again, I mentioned Dorothy Roberts' Abolition Constitutionalism was part of an entire volume in the Harvard Law Review in 2019 devoted to abolition. And this was actually had articles of abolition in other contexts, so in immigration and housing, employment, other areas. So I encourage you to take a look at that. Digitally, there's so much out there. So I did put a plug in for my students that put together the Digital Abolitionist, which is really an umbrella of other existing information out there. So it's a nice starting point. Angela Davis's Critical Resistance is a wonderful resource. Abolition Toolkit has a bibliography, again, of resources and readings. The Law and Political Economy Project, which I've already highlighted, that Amna contributed a blog to. That's not exclusively on abolition, but you can do, there's a search feature and you can pull out everything that discusses abolition. And then somebody, thankfully, has collected a ton of podcasts engaging with abolition. And so it's put together, those of you that have access to Spotify, it's put together as a playlist. And so you can hear lots of interviews with Ruth Wilson Gilmore, some of the founders of Critical Resistance. I'm pretty sure Miriam Cobb is on there, other organizers. I'm a big fan of podcasts. I know we have differently situated learners. Not all of our students dive into law review articles and case books the same way. And so I really like to assign podcasts throughout the term. Videos as well. I don't have any videos to share today, but start thinking about the more dynamic ways that we can introduce this material to our students. And then existing organizations for two reasons. One, to get inspired and informed by them. And then the other reason, to potentially partner with them. Whether you do that through your clinic or you're recommending that your students spend time potentially through an internship or an externship outside of class. I've already talked about Survived and Punished, the student that worked there. They have a lot of great materials. Bernard and I assigned one of their sort of booklets to our students during that week when we talked about abolition within the context of the criminal legal system. But they have wonderful materials. There's the Abolitionist Law Center in Philly that works with a lot of folks who are incarcerated. Restore Justice is the organization that we brought in folks that did restorative justice work to our class as guest speakers, obviously on Zoom. It's so much easier to do that kind of collaboration. We also had a formerly incarcerated person speak to our class, and then Adnan Khan, who started Restore Justice, ended up auditing our class for the rest of the semester, which was a real boon for him and our students to have that voice throughout the semester of somebody that had direct contact with the criminal legal system. It was a really powerful experience. And I want you to also think about, as you're inviting people into your class, particularly people that work in the organizing community that have been impacted by the criminal legal system, to think about ways potentially to give them an honorarium, offer them an honorarium. It takes a lot of time and energy, and it's nice that we can compensate that. And that's something that I'm trying to do more as I regularly invite speakers to class. And if you're not faculty already, think about ways that we can potentially compensate folks. So many more organizations. I won't go through all of them. Some of them are immigration-based. Many of them are criminal legal system, given my sort of own background. And then I think that was the last, slide. So I'm going to unshare the screen. That's my contact information. My Columbia address is good through the semester, and then I'll have a Brooklyn one, which you can always find me on Twitter. It's _ in between there. So I'll stop the share. Okay, so we're back. I see now that we are at 12:56, and there's lots of questions and comments that have come in. So maybe perhaps Allison and Layla, if I can get a little bit of your help.
So we had folks who are sharing some resources in
Oh,
the
great.
chat box. If people have questions, I think we have time for a question or two. So put it in the chat or just unmute yourself. But so appreciate all these resources and everyone's shared thinking. So great to learn from everyone.
I also, since I know this won't be a benefit for those of us that are watching this on the webinar later, but there is an event this afternoon at Boston College Law School. My former colleague, Ajmal Qureshi at the Legal Defense Fund, Senior Counsel there, is giving a talk on defunding versus reforming the police. Varying approaches to addressing police misconduct in the 21st century. So I'll go ahead and drop that. It starts at 4 p.m. Eastern time. I know folks are probably tuning in from all over. There we go. I hope we can, I will definitely be downloading this chat because I see there's a ton of helpful information. It was a real joy for me to put this presentation together. I don't always give myself the space in the room to reflect on what I'm doing. And so this gave me a little bit of an opportunity to do that. As much as I encourage my students to reflect, it's something that I could spend more time doing. And so this was a real boon for me in preparing this presentation for you. And I do want to repeat the invitation that I gave at the beginning, which is that this is very much a process for me. And I am learning and grappling and questioning and figuring things out as I go along. And I invite you to be in conversation with me. I know that's true of pretty much anyone that's presented through the workshop series, but to continue to lean on each other as resources.
Thanks so much. This was amazing. And I hope it inspires people to think about writing not only more about kind of abolish in their writing, but like the pedagogy of it, which you've just so inspired us to think about. Thanks everyone. We look forward to the fall. This has been just such a wonderful year, and we so appreciate you, Alexis. I kind of really jumped on you as soon as we were in the new clinicians small group, which I knew I shouldn't have, but it was so great to learn from you. And yeah, thanks everyone. Take care. We'll circulate resources, and we'll see you later in the year.
Thank you so much. Have a good afternoon.